No, I'm glad you guys came out. I know we had like 84 people come, or 84 people who signed up, and that's still a significantly good turnout today, so I'm really glad you all made it. I wanted to say a few thank yous before I turn it over to the panel, who you're actually here to see. I wanted to thank the IP Society for all the work that they've done. The executive board is over here. Ashley, Jeff, if you guys want to stand up, Dave to the back. But these people really made it happen. Eli's over here too, and Ann was outside manning the table. The two shy to stand up, but they're right there in front. We're also launching a mentorship program, and we have a lot of mentors in the audience. And mentors, these are practitioners that have volunteered their time for the next year, and they're going to be helping out 9 students, and they're going to be working with them over the year, talking to them about their career strategy and all of that. So I'm really glad that they were able to do this as well, and it's a year-long commitment, and they signed up, which is great. Also wanted to thank the Center for Professional Development and Career Strategy. I wanted to make sure I got that right. It's a pretty long title. They call themselves the Career Center, which is probably easier. They did a lot of work. There's a lot of interplay between them and the IP section, so that I'm really glad we had their support as well. And so I can stop talking, I'll introduce Joe Staley, who I've been bothering for the last 2 months, and he's probably glad it is today, so you will not hear from me ever again. So Joe, I've been talking to him a lot, and he's made this event happen. He's representing the IP section that is sponsoring this event. So thank you.
I'm a little taller than these microphones all the time. So my name is Joe Staley. I'm from the State Bar's IP section. I'm part of the executive committee there. And this is now the second year that we've done this event. Last year was a great success. So we had our first mentoring event that the State Bar helped put on. We had a great turnout, and Karin called me again this year and asked if we would help sponsor it again, and we luckily could make it work. So without further ado, though, I want to introduce the panel today. We have a terrific panel that's going to talk about ethics of patent troll litigation. And I asked them for a short bio, and being such a distinguished panel here, I got a rather large, well, not too large, but I got some reading to do. So let me get into it and introduce the 4 panelists here. So first we have Tim Holbrook. As you know, Professor Holbrook is a Associate Dean of Faculty and Professor of Law at Emory University here. He's one of the nation's leading patent law scholars with over 30 publications and over 100 presentations around the world. International and national media have relied on Professor Holbrook for his views on patent law, including Forbes, CNN, and The Economist. He's the co-author of Patent Litigation and Strategy with Federal Circuit Judge Kimberly A. Moore and John Murphy of Baker Hostetler. Professor Holbrook graduated summa cum laude as valedictorian from NC State University with a BS in Chemical Engineering and earned his JD at Yale Law School. He clerked for then Chief Judge Glenn Archer, Jr. of the Federal Circuit before entering practice at Wiley, Bryan, and Fielding in Washington, D.C. He's also taught at Stanford, Washington University School of Law, University of Denver, Stern College of Law, and Chicago, Kent. And Professor, like I said, he's going to be moderating the panel today. Next we have Professor Rissick. He received his undergraduate degree magna cum laude in Phi Beta Kappa from the University of Arizona, where he majored in English. He received his law degree with honors from Northwestern University School of Law. He practiced with Baker Botts and small litigation boutiques from 1988 to 2002, doing patent litigation, legal malpractice defense, and general complex commercial litigation. In 2002, he joined Mercer University School of Law, where he teaches legal ethics, patent law, and litigation, federal civil procedure, and other courses as well. He has authored the only treatise on legal ethical issues in patent litigation, and co-authored the only book on legal ethical issues in patent prosecution. In addition to serving leadership positions on ethics committees with the AIPLA and ABA and serving as an expert witness, he has written dozens of articles and given well over 100 presentations on issues at the intersection of ethics and patents. His articles and testimony have been adopted by both state and federal courts. In 2012 and 2013, he served as law clerk to Chief Judge Rader at the Federal Circuit. And next we have Bernie Zeider. He is the Chief IP Counsel for McKesson Corporation, which he joined in February of 2007. In this role, he handles all intellectual property matters for McKesson, which is, as you're probably aware, a Fortune 14 company. It's diversified healthcare technology and services. His responsibilities include growing and managing the company's patent and trademark portfolios, trade secret and confidentiality issues, and litigation of the company's intellectual property disputes. Prior to joining McCusson, Bernie was a partner at Needle and Rosenberg, PC in Atlanta, where he practiced all aspects of IP law and served on the firm's executive committee. Bernie received his JD with distinction from Emory University in 1998 and his BS in mechanical engineering, magna cum laude from the University of Notre Dame in 1992. And last but not least, and as Bob told me to say, certainly most important in your hearts, right?
Exactly.
He is a partner at Alston & Bird with their intellectual property practice group and focuses his practice on intellectual property litigation, counseling, and enforcement matters, with a particular emphasis on patent and trademark litigation. He has extensive experience in disputes involving various technologies, including electronic commerce and software applications, logistics and GPS-based systems, electronics, telecommunications, and prepaid and financial services products. He also assists clients in managing and protecting their IP portfolios, including coordinating their domestic, international, patent, and trademark activities. And Bob has extensive experience with so-called patent troll litigation. So without further ado, we'll, Professor Holbert could come up and moderate this panel for us.
Thank you very much, and I want to extend a special thanks to everyone for coming here from the Emory Law School, and particularly to the IP Law Society for organizing this event, and to the IP section for sponsoring this event. It's a great chance for our students to engage the practicing bar, and we're really happy to be here and hosting it for everyone. So there's been a lot of activity lately, in fact, a lot of activity in all branches of government with this thing called a patent troll. We've got the House of Representatives having passed legislation in December called the Innovation Act of 2013. President Obama mentioned patent reform in the State of the Union address. You know you hit it big when that happens. And he's offered some proposals to combat the troll phenomenon. We also know that the Supreme Court has taken 4 cases this term that likely bear on this troll phenomenon. And so obviously everybody is really worked up and concerned about patent trolls. Of course, the question is, who are they? And in fact, what are they? There's all these terms bandied about: non-practicing entities, patent assertion entities. Troll is kind of the pejorative term. I don't think most companies that operate in this space enjoy being called a troll. But the question that I pose for the panel is, who are trolls? What are trolls? How do you identify and characterize what entity is a patent troll? And I'll just throw it open to anyone who wants to take it.
All right, I'll jump in. Sure, it seems like a simple question, but it's actually extraordinarily complicated to figure. There's a wide divergence of opinion when you get into the question of how you define a patent troll. And for years, to me, it was sort of a cocktail party type conversation, a boring cocktail party, mind you.
Not to this crowd. This crowd would love that cocktail party.
But it mattered really. It was interesting to talk about, but to me, there wasn't a whole lot of sort of teeth or impact behind the decision of how you define trolls. I think now that we're getting into a phase of this whole phenomena in patent law that involves legislation, I think to me it sort of ratchets up. The definitional issues become really, really important because we're going to get to the legislative issues and the proposals that are in play in a moment. But now it actually matters. If you or your company or your client is a troll, then you are going to be, the intent, I think, of the legislature is to disproportionately harm you in terms of the impact that the changes will have. So, as Tim said, they're all over the board. Patent assertion entities, many would consider universities, research institutions to be patent trolls in that they don't themselves, in most cases, commercialize the inventions that they come up with. They prefer to license. Some of these definitions are offensive depending on where you sit. But I think figuring this out became more important than ever over the past year or so as we start to see troll-specific, facially troll-specific legislation come forward.
Yeah, a lot of people, it's sort of like pornography. You know it when you see it. And I think all the commentary from the president, from business leaders, from the press, it's all targeted to activities, not necessarily the structure of the troll. Everybody talks about abusive litigation and the abusive tactics trolls have. But, as a patent litigator, I've seen entities who, did not commercialize their activity and their litigation tactics are above board and reasonable. And I've seen large corporations who do commercialize their own patents, who are, if you will, in the gutter in their litigation tactics and how they assert their patents. And so what people are trying to remedy is the conduct, not necessarily the entity, but then how do you determine who is the right target? And I think that's the big debate. And so you see a lot of commentary about, it's a patent troll is someone who doesn't commercialize their own patents or their own technology. But we're going to carve out universities, we're going to carve out tech transfer organizations, we're going to carve out all of these other entities who we think are, who contribute to the good, so they can't be patent trolls. But what you're trying to really legislate is the activity once the litigation is running. And that's going to be I just think, a very difficult thing to do, regardless of whatever legislative proposals get through Congress, and if there ever is going to be any more patent reform, what it does with it.
I think in thinking about it, it struck me that nobody would call a solo inventor who came up with a great widget a troll because they don't have a facility to make that product. That's what we want. That's the American dream, is to come up with something. We would probably not call Google a troll if they own a patent and they do lots of things, they commercialize lots of things, but they don't happen to commercialize the particular patent they're asserting. We wouldn't call them a troll. And the more I thought about it, the more it seems to me that the troll label gets attached to people who don't, or things, entities that don't innovate. If all you do is acquire a patent from somebody else, then you're bad. If all you do is acquire these patents to assert them to make money, that is what makes you a troll. I think that's maybe the paradigm, but I'm not sure, like you say, that necessarily then fits with what we're going to talk about in a moment, these downstream, what do you do about this problem? But if you don't, or if you aren't careful in the definition, you end up throwing a lot of things under the bus that we probably don't want to throw under the bus.
Yeah, I think, it's the troll, the whole concept of a patent troll is obviously the effort behind choosing that name was to criticize, or it's a pejorative term, as Tim says. So everybody, no matter kind of where you sit, or most people, regardless of where you sit in the whole sort of IP framework, wants to avoid having themselves or their clients lumped into that definition. So that's why you have so many narrow slices here. Let me just throw out sort of a complicating example. My company, McKesson, we consider ourselves to be extremely innovative. Trust me, my clients remind me of it all day long. But we employ 7,000 or so engineers and what we call technologists. We file somewhere around 100 patent applications per year. So we're not the biggest, we're certainly not the smallest, but we consider ourselves to be innovative. We we pursued a piece of patent litigation against our top competitor in the electronic medical record space over the past 7 years or so, which just ended. It was a case that probably both professors are teaching when they get a chance. It has to do with divided infringement. Oh. That's the Akamai case that's going up next month. But so incredibly important to the company. We were very confident and invested in the case. But in fact, if you sort of peel back the onion, the patent that we litigated in that case was a patent that we acquired in an acquisition of a small technology company about 12 years ago. So we, McKesson, didn't come up with the innovation that led to that patent. It was another technology company, but we didn't do it. And in fact, strangely enough, I think this is quite rare, but this was true in our scenario. We have a competitive electronic medical record product to the defendants, but the patented feature was not active in our product. It was in the defendant's product, but we had not implemented it in our own. So I think those two things, you didn't invent it, someone else came up with it, and the patent is not on a feature that you exploit. Those are two sort of hallmarks of patent trolls in a lot of these definitions. I certainly don't think that my company considers itself a patent troll. But,
We do a
but
raise hands, you want to take a vote, see what the audience thinks of that?
Yeah,
That's good.
yeah.
I think the politically correct term for that is patent monetization, right? And that's sort of the catchphrase where a company takes an asset that they have, they may not be practicing it, but they monetize it by either licensing it or seek licensing fees through litigation. Do we think that that should fall under the troll moniker? Clearly Bernie thinks no, but he has vested interest in not doing so. It's his company, right? So do we think, Bob, do we think that is, if we're thinking, is that what Congress had in mind or the president had in mind? Is McKesson's activity the kind of things that they had in mind when they started talking about trolls?
Certainly not. I mean, what the hallmarks everyone gives examples of, and you hear about a lot of press is happening in this arena on the state level. I mean, if you follow it, you see states' attorney generals filing suits trying to press local state legislation to protect against patent trolls. What they're trying to protect is the small local business who is a downstream user, just acquired, if you will, a patented product off the shelf, literally. And that's what everyone's trying to protect. They're trying to protect, the small business in small America, and everyone thinks that's a great idea. But then how do you differentiate between the two situations? You can't from a legal perspective. If you didn't acquire the technology, if you're not practicing the technology, and if that has to be the hallmark, then what is the difference? And no one, Congress certainly is not thinking of McKesson, is not thinking of the Googles of the world. There's a big marketplace for patents out there. I mean, there's sophisticated companies who are actively in the market all the time. And there's big auction houses. Ocean Tomo is one of the most famous, a big auction house who's making a lot of money selling patents at auction for a lot of companies. And their customers or the bidders are sophisticated technology companies. It's who's who of everyone is out there when they do this. No one thinks Oracle or SAP or Microsoft or trolls at all. But again, what they're doing is no different. So to me, it goes back to people are trying to, remedy the conduct in what is viewed as abusive conduct. But then how do you label the entity that's asserting it? It's almost, I think it's impossible.
And I think I'll take both sides of the issue. You didn't make it. You didn't innovate in this area, and now you're trying to extract rents from somebody who is an innovator in this area. You're a troll. That's one way of looking at it. I don't believe that, but that's the argument.
it's okay.
The other side
Work it
of
out
it,
later.
Yeah, I can see it now. I'm never going to be hired by McKesson as an expert. On the other hand, you gave value to somebody who did innovate. You paid them money for their patent, I'm sure, along with other stuff. You created value by creating liquidity in a market for intellectual property, which is a very good thing. I don't know if there was if these were distressed assets, bankruptcy, we want people to pay money for those assets so creditors and shareholders get value. I don't know if that's what this was or you bought it, but you want liquidity in these kind of markets, so that's a good thing. And you are making stuff, maybe not this particular gizmo or feature, but you're making stuff, and that's a good thing. So to me, asking whether somebody is a troll or not doesn't help me get very far down the path, because I can argue both sides of McKesson, and obviously McKesson's not a troll. I mean, I would think not a troll in terms of President Obama's conduct speech or what Congress is trying to do.
So how about, just to push a little bit more on what we think trolls are, so we're thinking McKesson, maybe not.
Maybe.
What about the sort of situations such as actually the case with the Alice case in the Supreme Court? That's what the Supreme Court will confront whether software should be patent eligible. Alice Corporation doesn't manufacture anything, but the inventor is still part of the entity. And similarly, back when the BlackBerry case was litigated, you guys remember what BlackBerries were? They were these antiquated phones, right? At the time, it was really important. But that situation, the entity, the patent owner, also still had the inventor involved. So does inventor involvement shift our perspective as to whether the patent owner should be considered a troll?
It's certainly one of the things that bothers people. I mean, we're going to talk about ethics, right? But, when I was trying to figure out what in the world ethics has to do with this topic, which we'll get to, it's going to be interesting. Really what I kept thinking of were, what are the things that bother people about patent trolls? Because at my job, I deal with a lot of visceral reactions from my clients and friends when it comes to the topic of patent trolls, right? And I'm not sure they're really at their root ethical problems, but they certainly upset people. And separating the ownership of the patent from the person that came up with the idea seems to really bug people. In fact, it's one of the, if you talk to my inventors at McKesson, that's one of the most offensive things is, they didn't come up with that, and I try to gently at times remind them that we're in that scenario from time to time. But really that issue bugs people. People seem to be bugged by, they got a patent on that phenomenon, and it seems like disproportionately those types of patents get litigated by trolls or NPs these days. Those are really sort of the places where I see most of the ire here. And I don't know if that leads to ethics, but it certainly is what motivates people.
But even to the flip side of that, though, you often see, I really don't want to name too many names in this sort of scenario, but there's an entity out there, Acacia is well known. It's a publicly traded company. It's a patent monetization entity. I mean, it is a hugely successful company, and this is their business model. And in their model, they often, find patents, they acquire, they partner with the inventors, and they create plaintiffs where the inventor is, a member of the LLC or whatever. But anyone who's dealt with Acacia in the past, I mean, I don't think their litigation tactics, by the way, rise to the objectionable when you think of, abusive litigation. I mean, they have a tendency to invest in good patents, in my mind, and they have, when they bring a claim, they're good with it. It's a legitimate claim. But they bring the inventor along, honestly, for the optics of it, because the LLC they create has no other assets. It has no information. It is the inventor who's now living in their home that honestly may have never even met Acacia in person before, but so they're offering the inventor's involvement, but the inventor has nothing to do with the litigation, has nothing to do with prosecuting it. It simply is, they get a contingent interest, if you will, of the proceeds of any monetization efforts. So there, the inventor's involved, even though it's really only, I don't say for straw purposes. I mean, they do it, but I think they do it more for optics than anything else. But Acacia is one of the entities out there who is very, if you will, effective in the patent space.
And what do you do about the definition when you have this scenario? You have an inventor who came up with something, whatever, and he goes to, I was going to say McKesson, let's not
Bring
do
it on.
that. He goes to Acme Corporation, where Wiley E. Coyote is the chairman, and he says, look at this great thing I came up with, and they look at it, and they actually steal his idea from him, and they said, so what? Sue us. And he says, I don't have any money, I can't. So he sells it to Acacia or whoever, and they sue, and then they say, trolls are suing us. There's something really wrong with that scenario, and that scenario isn't that far-fetched, at least if you believe some of the clients that I've had over the years. So again, it's a factor, and it does bother people, but on the flip side of it, there's concerns that we should be, monitoring on the solo inventor getting damaged by Acmes of the world.
Well, I want some data on how often that is in fact the case. Because when you listen to Acacia and Intellectual Ventures and all the big NPEs, when the moral argument comes up, that is I think the most compelling justification for the business model. I just don't know how often that's actually the case, and I don't know how much the inventor's getting. Because if you think about Acacia being a public company. And IV, most of these are funds nowadays, right?
Yeah.
So they're even if they're not public companies with shareholders that are owed fiduciary duties, they're fueled or created or the acquisition money comes from investors, and they're not just giving their money away. There's an ROI there. There's it's like investing in a mutual fund. You're doing it as an investor with the expectation of making money, right? So. In that case, you've got the inventors making money, but a lot of people are. The shareholders are making money. The investors are making money. Of course, the lawyers are making money. I have no problem with that. But one of the things that's interesting to me about this secondary market that's developing is that there's a layer of money that's going to speculators that really have nothing to do. They're not defendants or plaintiffs or inventors. They're not even service providers to the litigation machine. They're just passive investors that didn't put their money in Vanguard funds, but instead bought Acacia stock. I don't know if that's good or not, but it means that that layer of cash is coming out of the system. It's not going to the inventor, it's not staying with the defendant who's, presumably being productive in society. It's going off in this other direction.
So one of the critiques that's been levied against the troll phenomenon is it actually is a private tax on innovation, right? In some sense, it's a drag on innovation. And so taking us more to the ethical side of things, do we think the fact that, at least in the classic sense of patent troll, where it is an entity that simply bought up the patent, doesn't do anything, simply sues people, is the fact that they're not participating in the process of innovation itself a problem? Should that be reflected somehow in the ethics of this situation?
I think there's multiple levels to that. Let me deal with the real ethical issue first, and then there's a broader issue. The real ethical issue, the real problem for lawyer ethics comes from the fact that patent trolls don't make things. That's not itself the harm or the evil, but what it does is it allows me, if I'm representing a non-practicing entity or a troll, to leverage that. I don't have documents. I've got the patent, the prosecution history, and maybe the chain of title on the patent and a few other things. I don't have very many witnesses, so I'm not going to, have a lot of depositions I'm going to have to take. I don't have employees who are going to be distracted from their jobs because we're dealing with all the stuff that litigation entails. I don't make things, so I don't have to worry about a counterclaim. I don't have to worry about whether Acme has a patent that they're going to assert against me and drag my company down and cost us a lot of time and money. I don't have a reputation in the marketplace to worry about, whether it's customer suits that get involved or customers hated or something else. So there's lots of things that flow from the fact that I don't make things, that make it so that I can impose costs, asymmetrical costs and discovery and all kinds of things on Acme Corporation. That's where I think the lawyer ethical issue comes into place, because lawyers shouldn't impose discovery or ask for discovery unless it's worth I forget the buzzwords from Rule 26, it's justified by the circumstances of the case. Lawyers shouldn't make frivolous claims under the Rule 11 as well as the ethical rules. I have less downside to that if my client doesn't make something. So I think there's the short term, there is the ethical rule that lawyers who represent trolls face, because they have the ability to leverage those things in an unfair way that I couldn't do if I'm representing Acme Corporation itself. The broader question is, is it unethical or bad in a broader sense? I don't know, but there's certainly when the rubber hits the road, those are the issues I see that it creates.
So you're saying that the fact that the costs and the burdens are asymmetrical creates an ethical issue. Why? That's the piece I don't get. Is it that it creates an even greater incentive to leverage that?
Yeah, I can use the cost that I can impose on you as a way to get an unfair settlement. I can use litigation costs and say,
okay.
It's going to cost you $1 million to litigate this thing, and maybe you'll get out on summary judgment, or you can just pay me $100,000 today. And that's where, in regular litigation, you're not going to have that, because both sides are going to have tons of documents and tons of witness and products and disruption. That, to me, is the nut of the problem. But notice it doesn't have anything to do with necessarily whether I innovate or anything else. It has to do with lack of documents and witnesses.
Well, the point you made a few minutes ago is the fact that there's a marketplace now for patents for small inventors that they didn't have. I mean, I've run into numerous cases where literally, I've deposed the inventor. Primarily, I do defensive litigation, so I deposed the inventor who literally was sitting at home when he or she got if you will, a cold call, and said, hey, I was on the PTO website, saw you have this patent, and actually you interested in selling it or licensing it to me. And then the inventor literally created this patent 12 years ago, tried for years to commercialize it potentially, get investors, failed, is in a business unrelated to the technology in which they sought the patent and had honestly forgotten about it, and they get a cold call. And 8 months later, I'm deposing this inventor because that call turned into a purchase, or a licensing arrangement, which immediately turned into a new LLC that was created 2 weeks later by the lawyers / investors. Now, increasingly, they're the same people, by the way, created this entity and started suing the world. And so to the inventor, is a small business owner or even just an individual who now is being compensated for the innovative process. So to your point a little while ago, you could say there is an encouragement for innovation because there is a marketplace now for patents that have been on the shelf otherwise and that were considered valueless. I still think they are in large part, and it goes to the point you're making. I mean, I've got all sorts of horror stories, or war stories if you want to call them, about that process where I've been in a courtroom and, you know, this is where I think really the ethical problem is given a lot of this activity, lawyers, to me, are in both sides, are giving up a lot of their ethical duties in the cases they're taking, the claims they're prosecuting or defending with the mindset of just the mill mentality.
Have you seen, that's years ago, I think before even the troll term had been created, somebody asked me to write a law review article about the ethical issues facing those who represent trolls. And I started thinking about it, and I realized there was this asymmetry, and I was like, yeah. And then I started realizing the real onus, if you will, falls on defense counsel. Because if I'm representing a troll, I want to be lean, mean, and efficient, because I'm probably got a contingent fee, and I want to get what I can out of it in a fairly effective way. If I'm defense counsel, man, I want to take discovery and churn that file and get lots of hours. I mean, do you think that that's also a part of this equation? Is there's not much of incentive on an hourly basis, I mean, cap fees and AFAs and all that, but on an hourly basis for a defense counsel to be efficient?
Well, there is a struggle with that, you know.
In-house counsels laugh,
Yeah.
by the way.
Well, as an outside lawyer, you know, if you hope to get repeat business from companies like McKesson and bright people like Bernie who watch this, you can't do that, right?
Exactly.
I mean, you know, well, you know, you try to be effective, you try to be mindful, but there's a balance as to, you know, again, you can't take any discovery from the plaintiff. There's nothing to be had, so how do you really prove your case? A lot of these plaintiffs, who cares about discovery? They hired an expert that said you infringed before they even filed suit. So,
Well, they have to.
well, not necessarily. Well, they hired an expert that said you infringed before that expert even looked at your business. And so they just want to get to a jury as quickly as they can because they know the risk there. The bigger issue, like you pointed, is sort of the discovery process. Now there have been some limits placed, but you know, I've been in court. I was literally in court, not to get into too many war stories, the week after Judge Rader issued a couple of years ago his model order on e-discovery, which a lot of courts picked up and ran with. And I was in an unnamed court with a magistrate who picked that up, and it was surprising given the court we were in. And I was with a reputable firm on the other side. I was defense counsel representing a number of retailer defendants on some electronic commerce claims. You know, their website, the e-commerce platform, infringes this patent portfolio. And I'm arguing to this magistrate judge why, of course, the software is the best source for evidence as to how our e-commerce platform works. This reputable lawyer with a reputable firm on the other side is arguing to the magistrate why every email within my company, within 30 different departments, is the most best evidence of how my e-commerce platform works. And this magistrate luckily had read Rader's order and was trying to put it in place, but this was the first time he was doing it, so he's trying to figure out what's the best course. And I'm arguing, let's look at the software, let's cut to it, and plaintiff's lawyer is arguing, Your Honor, I need every email they have that references their website. And when my clients are Fortune 500 companies, that's a lot of email. So I'm not going to say this lawyer was unethical. I had issues with him and his conduct out in the hallway afterwards. We had a spirited conversation. I won't repeat what I told him. But you know, there are good lawyers on both sides of this who and that's where I think with the troll conundrum, you see a lot of the activities on both sides kind of going to the extremes more often than maybe 5 or 10 years ago.
Yeah, well, the asymmetry definitely creates new and different incentives or temptations for lawyers to violate the same old ethical rules that get tested in non-troll litigation, right? That's sort of the way I think of this. This troll issue, the business model, creates a very acute business problem for businesses, for operating companies, that we have simply not figured out a solution to yet. I mean, there's just not a satisfactory solution supplied by the court system because we're getting creamed in discovery. And the length of patent cases is just conducive to a burn rate that just really hurts. I will say this about the plaintiff, the NPE side. they've really figured out how to be efficient and how to put together a strong litigation team on a contingent fee basis or on an investor-funded basis.
Yeah.
That, operating companies just haven't figured out how to do that effectively on the defendant side. So all of these factors. I mean, I guess what my observation here is that I don't see any of these issues as really ethical issues that are new to this forum.
Sure.
Right? These are all, it's because you have such a tricky business problem that lawyers are trying like hell to solve for their clients. They're stressed into making the same ethical compromises that got them in trouble in all the old models of litigation, but just sort of with a different engine behind it now.
Yeah, I agree with that. I don't think there's anything new. It's just, what is it? New wine in old wineskins or whatever that. No, but I'm old. There's some expression that's like that.
No idea what you're talking about.
So in some sense, litigation has these pinch points where you can try and get at the ethics right. In theory, if we heighten pleading standards, which people have talked about to match the Twombly and Iqbal standards. But what about pre-litigation ethical concerns, right? A lot of the big, at least PR complaints against the trolls have been going after the mom and pop coffee shop, and they're never going to get into court. They're just going to pay their $1,000 and settle and go away, right? And so are there any ethical hooks? You would think that the ethics of the law should control in that context as well, right? That the way that they engage with a potential infringer should have ethical dimensions. Are there things that they're doing that are unethical? Are there any tools that these mom and pop shops could have to try and fend off some of these suits on an ethical basis?
I mean, on the plaintiff side, they have the same pre-suit investigation under Rule 11 and no frivolous claims. I mean, the ethical rules are the same as everybody faces. The problem you have is that realistically, mom and pops, if they can get out for $1,000, they'd be stupid not to. And the only thing I know of that's out there, there's some state attorney generals who are trying to make it so that you can, I don't know, their antitrust claims
it's like
or
consumer protection stuff.
Basically consumer protection claims, but it's still litigation to bring a suit,
Right.
and hire a lawyer to bring a claim, and to prove the claim was objectively baseless. I mean, it's the same stuff. You're buying more litigation. It's not an easy way.
So you need somebody to stand up to the plaintiff's lawyers to say, this is a frivolous claim. It's not going to be the mom and pops, and so you're left with maybe it's a collective action problem. If they could all get together and band together and defend, they could do it, but I don't see that. I haven't heard of that happening. Maybe it has.
So maybe creative law students looking for a nice business model, find a way to legally aggregate these defensive claims, right?
There we go.
And RPX is sort of the patent aggregator on the defensive side, is this group that buys up patents and then licenses them to their groups, but that doesn't seem to work for the small mom and pop shops.
It doesn't. In a lot of suits, you do see a lot of defendants do join together in these joint defense groups. When a lot of these trolls or NPEs, they'll file serial cases in a district or multiple districts, and some of them will be consolidated in MDL proceedings. A lot of times now, a lot of judges are just sua sponte consolidating all pending cases filed by the same plaintiff in sort of a mini MDL. So the trolls have gotten around the joinder issues that the American Invents Act tried to remedy, but by that sort of conduct. But if you're a small company, a small mom and pop, it doesn't matter how big or how, the numbers of your defendants, just given the cost of litigation, regardless of big firm, small firm, hourly rates or whatever, just the cost of litigation is the most significant factor. And I've seen more in the last 2 years, a lot of trolls whose opening settlement demands out of the box. I mean, they'll file suit, maybe not even serve process, contact you, and it's the first offer out the door is a 5-figure number. Now, that's a lot of money to a small business. It may not be a lot of money to other businesses. It depends. You can, the relative merits of it, but quickly sending the signal that they don't want to litigate, you shouldn't either, and I can license you cheaper than you can hire a defense firm to defend you.
Or to read the patent.
Or even that.
At this point.
Yeah, the problem with that, though, the flip side, if you on the defense side, a lot of times it reminds me of sort of the bad faith insurance model too, because these days a lot of the patent trolls out there are in the software space, technology space, e-commerce space, and you're hard pressed to find a technology vendor, regardless of what their agreements say. Now, there are some notable ones, but a lot of the technology vendors know that if they say, I've got this exclusion in my indemnity, I mean, think if you buy a product off the shelf, that supplier should cover you under the UCC, under whatever agreements you got. But you know what? Sometimes you have to spend money to pursue the vendor too. And it's cheaper. The plaintiffs know it. It's cheaper than to still settle them to even chase sometimes your supplier. And the suppliers know it too. If they push back hard enough, it falls on both sides. And so you're in the middle. It's the small business often that gets squeezed.
So a lot of these issues seem a little bit like whack-a-mole, right? And so I think a lot of the legislative efforts are also a bit of whack-a-mole as well. And so we've already talked about that there's a lot of state-level efforts, particularly to protect the mom-and-pop shops. And anyone care to elaborate? Do you think those efforts are basically a form of unfair competition, right? That if you act in this way and start sending these demand letters, particularly if they're not justified, but probably a weaker standard than, say, a Rule 11 violation, that can open you to prosecution by the state attorney general. I think that Nebraska has these, quite a few.
Yeah.
What do the panelists think about the efficacy of those? Will they survive sort of preemption challenges? How viable are they?
Not very from what I've seen. I mean, a lot of the state AGs that have been trying this, like Nebraska has been very notable. I think Vermont has a statute in the books, and I think they talked about it here in Georgia even. I mean, a lot of states are contemplating it. And you can have a state statute on the books, which, how do you enforce it? There really hasn't been any litigation on the state statutes where people thought they could see some fodder with some of the state AGs making some press over it, but by and large, those that have done have been slapped down with litigation. Injunctions by federal courts saying preemption or First Amendment speech or, what in various different levels. And so some of the state AGs who were making noise about it have given up. So I don't know that ultimately, I think there's going to be a state framework. What they're trying to avoid the preemption issue, they're trying to deal with this issue of demand letters, this issue of sending a demand letter that is not well-founded, is somehow violates consumer protection laws. And I think those sorts of statutes will survive may survive a challenge, but still it's just in the cost to bring that claim. It's the same thing. If you get the letter, you can bring a state claim. You're going to go, if you get a demand letter, but you haven't been sued, is a client, a small business, then going to go hire a lawyer to go bring a suit for violation of that statute? It's almost like proving a malpractice claim. You have to prove that the underlying merits were objectively baseless. It goes to the same issues that the Supreme Court's dealing with now. How do you determine for some of the exceptional case standard, prevailing party issues in front of the Supreme Court on fees? How do you determine what's the right way to describe that conduct? How do you do it? And when do you label it that way?
Yeah.
Could the Attorney General act like the aggregator? I'm thinking sort of a parallel to public nuisance, right, where they actually aren't requested by a private party necessarily, or the private party doesn't have to bring the case, but the AG, hearing complaints from its constituents, will then sue on behalf of all of those similarly situated plaintiffs.
Yeah, that could be, but I think the real action is going to be at the federal level. I mean, I think the state stuff is interesting, but obviously it's heating up, right? We saw in December, I think it was, the House by an overwhelming margin, but that part was interesting to me. So the House, I looked up the numbers this morning. The House passed this Goodlatte bill in early December by a margin of like 325 to 91.
Bipartisanship is not dead.
Right, and this was, remember we spent the whole first half of October shut down, right? And so these people could not agree on anything through the whole summer and the fall. And then I was shocked to see this thing fly through, 6 weeks after we ended the shutdown. And so, that's interesting in itself. I think I'm trying to figure out how that could have possibly happened, right? Because both sides of this issue are very well represented typically. Like, if you look at amicus briefs and that sort of thing, on both sides of most patent issues, they're pretty evenly spread. On one side, you've got, these days, largely software and electronics. And on the other side, you've got pharma and biotech. And, they disagree on standards for invalidating patents. They disagree on lots of things, with pharma generally looking for stronger patent rights, and software electronics, with one eye on trolls, sort of fighting that battle. This is my theory. I want to see if anyone agrees or disagrees with this, but on this troll stuff, so I think the troll is generally aligning with pharma traditionally on some of these issues where they're looking for stronger patent protection and maintaining validity standards. On this troll stuff, pharma drops out. None of their lobbyists, none of their PACs, none of their people are really concerned about this because it's a neutral issue for trolls when it comes to the litigation abuse type corrections that are in this legislation. And so, this was a total landslide. I read an article also this morning, see when I do my preparation for this. I read an article this morning that Intellectual Ventures, which is rumored to be the largest patent holder in the world at this point, about a month ago filed paperwork to start its own political action committee. So, I think this thing is going to heat up. I think that just because it was a landslide in the House, that just means that the lobbying on the troll side is late, not that it's going to be absent. And to be honest with you, in my opinion, they've got some really good stuff to argue about. Imposing fee shifting for all patent cases, that's very dramatic, and it's sort of largely unlobbied, in my opinion, on the losing side right now, the side that appears to be sort of going to suffer these legislative setbacks.
I was this morning when I was preparing, I saw that there's Senator Leahy's scheduled hearings on his version of Goodlatte's bill, I think for like tomorrow or Wednesday. So it is moving.
The Senate generally thinks, of course, they're the experts, and so they generally don't like the House bill, and they have different views of it. So it's interesting to see what the Senate ultimately does. They've sort of had more of a piecemeal approach than more of an omnibus. Even then, you could say the Innovation Act doesn't cover all the issues, but it is a pretty far-reaching, in fact, that it treats numerous issues where a lot of the Senate action thus far has been very isolated. Fee shifting has been a big piece of it. They've talked about creating a bond system, making all plaintiffs pay bonds when they file suit, so that there is money to go after for fees, because that's the other side of it. Even if you are, in the very rare occasion ever, to say you're a prevailing party and you're the defendant and you've incurred millions of dollars in defense fees, the troll is an LLC with an asset. You just invalidated the one asset they had. So where are you going to get your money from? That's sort of the real issue, even on these fee shifting things. Even if you shift it, given the model, more defendants win their fees, unless you then are going to then take it out of the plaintiff's bar, which I don't know that lawyers generally are going to be as receptive to making sanctions as easily, or it's like, fees in that sort of case, a prevailing party case, to be visited as easily on counsel. I'm not advocating for that, but I'm just saying, by and large, even in these fee shifting provisions, which gets the most press, there's still practical problems with that.
Well, do you think that Congress is the way to act, or do we think that the Supreme Court, we should wait a little bit? The Supreme Court has two fee shifting cases in front of it. It's got the issue of definiteness in front of it, which is a huge issue with a lot of the troll certain patents. And then has the patentability of computer software, period, before it. So do we think the Supreme Court might be the better one, or do we think that Congress is the better institution, or do we fear both?
Have you heard, Scylla and Charybdis? Does that, rock in a hard place for those of you who are younger? I think the Supremes will make it easier under 285, and they'll fix the deference that is owed to district courts. I think the statute actually is relatively clear that it doesn't require objective and subjective frivolousness, or whatever the terms are. When you get into 101 and all that, I don't know what they're going to do. I'm worried about what they're going to do personally. But I think my guess would be, and you guys probably know more about this than I, if I'm a senator, I don't want to go down this path when in 2 months it may all be fixed and I don't have to do anything. So my guess would be that in 2 months probably is 5 seconds in legislative time, so nothing will actually happen. So my guess would be that there'll be a lot of hearings and then not much will change, maybe clean up by the legislature on what the Supreme Court doesn't mop up, but that's...
Yeah, David, I agree with you on that. I think, and that's my recollection of how it went in the run-up to the America Invents Act, right? That was a much more expansive legislative effort 2 years before it actually passed, right? So, and the courts went after issues one by one, and so I think it's the most likely case here. Same thing.
Hear Judge Rader say, says leave it alone. The courts already have the mechanisms. We just need them to act on them more often. And you've seen some of the courts do that. I mean, the two most heavily filed districts for these types of claims are the Eastern District of Texas and District of Delaware. Eastern District of Texas has started putting in model rules on limiting electronic discovery, model rules on limiting numbers of claims and asserted invalidity references. A lot of the District of Delaware is not really changing their model rules per se, but literally as we speak, I'm involved in cases where some of the judges up there are saying in scheduling conferences, I'm going to redo the way I handle these patent cases because this isn't working anymore. And so some of the judges up there, I think probably tired of all the filings in Delaware, are changing the way they do it and are now talking openly about limiting discovery, putting claim construction at the front of the case, and doing other things that defendants have been crying about for years, about if you could do this, we could get to the merits more quickly without incurring significant discovery costs.
I'm curious what you think about, because I've heard some proposals where they say no discovery or almost no discovery until after markment. Do you think that's really viable in a lot of cases?
It's viable in some, but not all. It really depends on the technology. And and I've seen, for example, I do represent a lot of retailers, and so they didn't build the technology. They get sued on their e-commerce platform. And looking at that, how much discovery can you take of them? That's to the merits. Now, if the plaintiff needs discovery of their providers, they need to go do that. But how much discovery can you really get to on the merits of the underlying claims, that quickly? But if it's a competitive situation, a legitimate or traditional patent case, two big competitors, McKesson going after one of its big providers, then you may, big competitors, you may need that up front. And so I think that's why there's not really model rules in place, but I think the judges in Delaware are talking about trying to look at the specific cases and take action to change how they schedule and manage those cases from the beginning, realizing if they put a little more effort at the front, it'll get rid of them on the back more quickly.
I think we still have a little bit of time for some questions, and I'm assuming the mics up here might be so we can actually extend the questions to people so they speak in the mic if we have that. Assuming the panelists are receptive to questions.
Sure. I think that looks like Mr. Staley's responsibility to potentially take the microphone and run it around. Just kidding. Don't he'll extend.
Don't hurt your knee.
Exactly. Questions?
I have a question, but I don't need a mic.
Okay. I'll repeat the questions for everyone.
So you spoke a little bit about, if there are two sides to the same central issue, one of them is how do you increase the cost to the plaintiffs? And part of that is the fee shifting and whatnot. What about decreasing the cost to the defendants, particularly the small, medium-sized businesses, through increased insurance options? And is there a way to make that model financially viable for investors who might want to defend against this?
I think that, Mark, I think that's a really good, that's a good avenue to chase here. I mean, we've seen, okay, so this is a problem that I think there's still plenty of room for innovation to fix it, right? I mean, we're inventors, aren't we? Yeah. And RPX, I think Tim alluded to RPX earlier. That's, that's one innovative, I think. Effective or not effective, I think, reasonable minds may differ on that. But that the RPX model, the subscription model, is one way of attacking this problem. I think you're right that, ever since we started, insurance for patent claims has been basically prohibitively priced, and so that's not something that I've seen. That those insurers have not beat down a path to my door offering that sort of coverage. There hasn't been a funding solution or a financial model applied to insurance that is attractive to companies like mine. But we're ready for that. I think among my clients, I get asked a couple times a year, what about insurance? What about insurance? And the product just doesn't exist yet, at least not that I've seen.
I think it would, to be honest. The problem, I guess, is that's just a slippery slope. Lawyers don't like to accuse other lawyers of unethical conduct. And so it's a very tough, and we have this debate a lot with a lot of the claims we see, and so it's, you just don't want to be the one to throw that rock because of what it means and how it can then really go down that path. A lot of times courts take that extremely seriously, and judges will get offended if you even suggest that how dare you accuse this other member of the bar of violating Rule 11 or even suggesting that they're pushing the line. You better be darn well right if you're gonna do that. And so there's such the stigma with Rule 11 that either bringing it or for courts even granting it, that it has not thus far been an effective deterrent. If there's a way to change the standard, maybe just semantics, right? Just call it something else under the Rule 11, then maybe people get away with it. But if you think about it, arguably you're accusing someone who then will probably ought to be reported to the bar. Really, if you take Rule 11 to where it goes, and then you're getting into all sorts of issues that people nobody ever wants to be a part of.
And further to that, I forget what the reversal rate is on claim construction. What is it, 40%?
Oh, it's dropped down to about 30% now.
30%. So you're going to say to a judge, Your Honor, they're frivolous in their position on what this claim means, even though chances are you're going to get reversed in what you say it means. There's an awkwardness to it, that reality of what, and I think a lot of judges realize that they're making a guess, and how can they fault somebody and say you were, violated Rule 11 by guessing wrong when chances are I'm going to guess wrong with what I'm saying here. So I think that's behind it a little bit too. It's also, it would be pretty minimal fee, it's not minimal, but it's fee shifting for specific papers. So it's going to be somewhat limited in what you can recover.
Yeah, the patent is presumed valid, right? So, I've been faced a lot of patents that I know, what I've seen, everyone ought to sort of agree this patent's invalid. Here's the prior, I've shown it to the opposing counsel. And they're like, you got to prove that, my patent's presumed valid. Does that get over the Rule 11 hurdle? So it's, I agree with you that some mechanism to put plaintiffs or their lawyers, to make them go through their paces more before they bring a claim would be beneficial to everyone, I think, but there needs to be a better enforcement mechanism, and Rule 11 I don't know that people are that's not going to help.
The only thing and I'm just thinking this on the top of my head because I prepare even during presentations. If you force claim construction earlier, there's most of the Rule 11 cases where the judges actually impose sanctions are for really stupid things like your client doesn't own the patent or it lapsed and because maintenance fees weren't paid, then they slap you for Rule 11. But there's a number of Rule 11 cases where what happens is the judge gives a Markman ruling, and under it it's just crystal clear that you don't infringe or the defendant doesn't infringe, and they persist. They persist in pursuing infringement. Well, what if you made it early on and got the claim construction early on, and then you were to couple it with more rigorous Rule 11 enforcement? Maybe that might be a partial solution, but think about it. It's a good question.
I did find it interesting, the shame factor of alleging Rule 11. It will allege inequitable conduct in every case, which is effectively saying the same thing, right? That somebody has violated a duty of the patent office.
But it's not the lawyer.
Yeah, that lawyer's no longer around. So.
Yes.
All right, I think that is our time for the evening. We give our panelists a round of applause for a wonderful
Really good.
And please join us afterwards.
Lack of preparation helps.
Thank you so much.